Custody can be modified whenever there has been a material and substantial change for the children or one of the parents. It doesn't necessarily take a lot. It's supposed to be a material change, so something that matters, and it's got to be substantial enough that it's worth the court's time. But the family code really leaves wide open what is the definition of material and substantial. Honestly, in practice, if a party they file a modification, they raise the issue that something has materially and substantially changed, it's really hard to convince the court that there's not been a change. I will just admit, there was a time where I used to spend a lot of time trying to fight the other party and show the judge that no, there has not been a change. Nothing has changed here. Therefore, they don't get a case. But ultimately, what I've discovered is if one parent alleges there's been a change, the court wants to hear it. When can you file a modification? If you think, it's time to modify child support. If it's been 3 years since the last child support modification, if your pay has gone up, if your pay has gone down, if the other party's pay has gone up, if their pay has gone down, they'll probably be the one filing the case. If the custody order no longer works, for example, you had a custody order for the children when they were little, but now they're in school, and that custody order doesn't work anymore, the possession schedule doesn't work. Or what if you had, a possession schedule when your kids were in elementary school, but now that they're 13, 14, they're in sports, they're, almost old enough to drive. There's all kinds of things that have changed in their life. That old possession schedule doesn't work anymore. Basically, as soon as one party alleges that there's been a material and substantial change, then it's time to start a case. Some key factors to consider when you're thinking about filing a modification. I think one is going to be the cost-benefit analysis. If you're doing a child support review, what if the child support amount in question is relatively small? If you spend $3,000 or $4,000, $5,000, $6,000 on a child support case that bumps your child support up $20 a month, you're never going to recoup your litigation cost. You might want to file a modification for this little thing over here. And as soon as you do, the other parent wants to come in and now they've got a big thing that they want to change. Well, you started it for something small, but you can't rein them in. Their case could be really big. All you wanted was to just look at child support. Well, now they're wanting to flip custody. And in fact, that's an example that we see a lot. So here's how it works. First parent files a case and says, look, it's been 4 or 5 years since we last did child support. I want to file a child support mod. So we file a case just to look at child support, and let's just adjust child support up to make sure it makes sense. Then the other parent says, oh, you're filing a child support modification? Well, that's okay because I want to flip custody. And so now they go hire a lawyer and they come in to completely flip the custody schedule and have you paying them child support. So now you're wishing you could unring that bell, except there's no one ringing the bell. Once you've started a case, it's open for all purposes. You just won't say, oh, well, the possession schedule doesn't work. He never takes his Thursday visits, so I just want a new case that cuts off his Thursday visits. And then he turns around and files a case and says the reason the Thursday visits don't work is because you're a terrible parent and you're alienating the child, and the child doesn't want to come on Thursdays, and it's all your fault, and we need to flip custody. Opening a new case has risk. Number one, you can always lose in court. Number two, it could cost more than it's worth. And number three, if you open the door, if you crack it open, it's open for all purposes. And starting a case often invites the other party to start their own case, and once that's done, you can't unring that bell. Once you've weighed the risk, and I will tell you, I hope that weighing that risk involves consulting with a competent lawyer in your area. Right? If you're here in Tarrant County, you're one of these surrounding counties, we're happy to have that talk with you. Not everything is all financial. When we talk about the cost-benefit analysis, I'm not talking necessarily about the sheer cost of something. What is your result worth to you? What is the cost of all the litigation just to get the modification that you want? So once you've weighed the risks and you've weighed the opportunities and you've figured the cost, once you do that analysis, then starting the case is relatively easy. Your lawyer will draft a petition, we'll get it filed with the clerk. We'll get the other party served, set a date for that first hearing, and now the case is up and running. Once the decision is made to file a case, the actual process can be done in an afternoon. Let's talk about some steps to take before you actually file the case. Obviously, you meet with your attorney and we will start working through a strategy for you based on your goals. And then what we're going to want to do, I don't want to know just the good stuff. I need to know our risks. I can't give you good advice without knowing the whole situation. As with any time you're going to deal with a lawyer, your lawyer needs to know the truth. If there's a drug problem or you have a substance abuse problem, we need to know that on the front side. If your new boyfriend or girlfriend has a criminal history, we need to know that on the front side. And then what we want to do is help mitigate that damage when we get ready to go to court. So if there is a drug use problem or something like that, obviously we want to get you drug tested and we want to get you clean before we start this case. You can't go into court saying the other parent's a threat to the child if you are dirty for illegal drugs. We're happy to help, advise about getting your ducks in a row so that when we go to court, you've got clean hands when we're making allegations about the other parent, if that's what is required. The prep work to get ready for a case, make sure your hands are clean. Make sure that you are encouraging the child to take the child's visits. Make sure you are not being an alienator. Let's log and document the other parent's failures. Now, I do believe in helping the other parent be the best parent they can be, but if that parent routinely misses their visits, I want you to take a log. Start making a note of the visits that are missed. When were they late? Are the kids prepared for school after their visits with the other parent? So we can start building a documented history of the other parent's issues with their parenting relationship with the child and their co-parenting relationship with you. Obviously, if the other parent is sending you threatening, harassing text messages, or they're calling routinely and they're harassing you at work, or they're threatening you, those things are going to be items that your lawyer is going to want to see because those are going to be exhibits. Let's flip that around on the other side. As you are co-parenting with the other parent, you have to be prepared for future litigation. Obviously, we hope that you and the other parent will be great co-parents, you all get along great, and we don't have to litigate again in the future. But it would be silly to presume that you're never going to have to litigate again, especially if you've got small children. Presume that every message you send to the other parent is going to be used against you in court. So keep your words soft and sweet because you never know when you might have to eat them. Don't send harassing, threatening text messages. Don't leave hateful voicemails. Even when you're calling the other parent, they're late to a pickup. Don't be screaming at them because they could be recording that too, and now you sound irrational because they're going to play that in court. Social media is huge. Feel free to post pictures of your kids and their events. You got your kids playing baseball or t-ball and you're at the game. Post pictures of that. Celebrate wins and losses. Don't blast your spouse on social media. Everything that you post could be used in court. And if it's bad, it's going to be used in court. When we start talking about preparing for your case, get your hands clean. Don't be guilty of the things that you're accusing the other side of doing. You need to be clean on drug tests. That's optimal. Make sure that all of your messages are safe and friendly and co-parent related. And then, of course, you want to log and document bad acts by the other side and just, failures of co-parenting so you can show a pattern. Those are the things you're going to want to do as you prepare for a case. One pro tip, focus on being a parent. Don't worry about being a litigant. Yes, I do want you to document things, but I don't want you to spend so much time documenting that you forget to be a parent. Spend your time being the best parent you can be and helping the other parent be the best parent they can be, and then document on the side. You're going to be a part-time litigator and a full-time parent.